rupees 50,000 with 2 sureties of like amount, one of whom should be a government servant with certain conditions. Conditions are mentioned in the order.
Lordship. Well, there. Please, your Lordship.
Yes.
FIR, your Lordship, and the base, your Lordship, 11 years. Yes, sir, your Lordship, got it. Annexure 2, Annexure 1 is the identity card of the principal government servant. Annexure 2, 11 is the FIR. It is law on 2012 to 2023, alleging that it is filed by the victim's brother that petitioner issued to marry the victim girl, but subsequently got married. It's false. An allegation of kidnapping totally false. Page 18 kindly peruse your Lordship. The
No, what is the allegation?
allegation is that petitioner issued to marry the victim girl, informant's sister, but subsequently not married, then made physical relation. Both are made, but fact is something different, your Lordship. Page 18. FIR loss in 2012-2023, but I have filed the petition on 12-12, your Lordship, before the executive magistrate that victim girl forcefully entered in the house of the petitioner. Initially, there is a proposal from the victim side, your Lordship, informant side, to marry, solemnized marriage with the petitioner refused to marry, informal marriage. There is no rough relation. After the victim girl, your Lordship, entered into the house of the petitioner on your Lordship 10-12-2023 with some other person, forced the petitioner to solemnize marriage, but petitioner refused, and petitioner is not staying in the house, your Lordship. In the restaurant, petitioner is a government servant. He is staying at Gwalpara, and incident took place in Kolgasia in Barpeta district. On that day, also petitioner not present in the house. He was at working place at Gwalpara. Is a government servant, and after that, family members, victim girl petitioner as a family members to bring the informant petitioner at solemnized marriage. But petitioner did not. After that, on 12-12, after 2 days, petitioner himself filed a petition before the executive magistrate to direction to the Kolgasia police station, OC, your Lordship, for your Lordship entry. Page paragraph 20, relevant portion, page 20, your Lordship, and the petition, it is filed under section, your Lordship, 107-151 CRPC, and page 20, your Lordship, middle portion, your Lordship, there is every possibility, your Lordship, page 20, your Lordship, what is? There is every possibility to commit an unpleasant incident by the opposite party. As a result, the complainant and his family members will feel in trouble. Moreover, the opposite parties have been threatening that they will file a false case and arrest the complainant and his family members. Therefore, it is required to take out the opposite party from the parental house of the complainant. Thus, the kindly to admit this petition, give a direction to the officer in the Kolkata police station to take out the opposite party, one, from the parental house of the complainant, and further to take necessary steps against the opposite parties for safety security of the complainant's family members. And after that, your Lordship, district magistrate, your Lordship, it is forwarded to OC Kolgasia, but victim was not required. After 2 days, after 8 days, your Lordship, the incident FIR lost. But kidnapping is allegation of kidnapping and detained unknown place, it is a false allegation in the FIR, your Lordship. After filing of this my petition, 8 days they have filed loss instead of releasing some allegation that issued to marry subsequently. Both and victim girl is a measure, both are measure, your Lordship. Petitioner is a government servant and victim girl is a
No kidnapping, abduction, only threatening is there.
your Lordship.
No abduction is
No,
there.
no, nothing. He himself entered in the house of the petitioner. You can say, yeah, this petition, your Lordship, I filed. Page 18, your Lordship. And Barnicola, page 22, your Lordship.
Now, what is your submission? You had relationship with the
No, your
victim.
Lordship. I have stated of fact, paragraph 4, your Lordship. There is a proposal from the petitioner informant side to solemnize marriage, formal proposal. It was refused. After that, Your Lordship, paragraph 4 I have submitted, Your Lordship. There nothing was there, Your Lordship.
But there was some relationship between you and the,
No, Your Lordship.
there was no
No
relationship.
relation, in fact. Effectively, no relation, Your Lordship. Formal marriage proposal was there, it was.
Case diary is there.
Case diary is here, 164 is here. 164 of course shows that they were in relationship, although she makes certain allegations in between. She said that he had made some
Since-
photographs and all.
Since when they were in relationship?
What she said is,
1 year.
yes, প্ৰায় এবছৰ মান নৰ আগত হাফিজুৰ ৰহমানে মোক বিয়া কৰাবৰ বাবে চাব গৈছিল।
Hmm.
তেতিয়া আমাৰ ফোনত কথা বতৰা হয়। যোৱা এবছৰ ধৰি আমাৰ মাজত ভাল পোৱা হয়। So they were in relationship, she said. Initially he went to see her. আমাৰ শাৰীৰিক সম্পৰ্ক হয়। Then she said that he had taken some photographs, made some videos, and he threatened her. But then again, her subsequent statement shows that she was in love with him. She was agreeable to go marry him. In fact, he called him. He went to that place. He took her to his place. And then what she again said, after 2 days, she was at his place. After 2 days, he again left her. And then the family members had tortured her. When she shouted, the neighbors came to know. And neighbors had, in fact, told the parents, Siori Diat, tar ঘৈণী মামনি আৰু প্ৰায় আৰু মই কি বাচি যাওঁ তাৰ
She herself went there.
she herself went there.
Let him appear before the eye.
Acha.
Heard Mr.
Yes, sir.
S. Islam, learned counsel for the petitioner. Also heard Ms. S. Jahan, learned additional public prosecutor. This application under section 438 of the Code of Criminal Procedure, 1973, has been filed by the petitioner, namely Hafizur Rahman, who is apprehending his arrest in connection with Kolgosia PS case number 186/2023 under section 417/366/366/342/34 of the Indian Penal Code. The gist of accusation in this case is that on 2012-2023, one Mujammil Hussain had lodged an FIR before the officer in charge of Kolgosia Police Station, inter alia, alleging that the present petitioner by giving false assurance of marriage to the sister of the first informant, made forceful physical relationship with her, and on 10/12/2023, the present petitioner, called the sister of the first informant to Bamuntari near the bridge of the Beki River under Kolgosia Police Station. And since then, this sister of the first informant was missing. And later on, it came to the knowledge of the first informant that the present petitioner had abducted the sister of the first informant. Learned counsel for the petitioner has submitted that the allegations leveled against the present petitioner in the FIR are not true. It is submitted by learned counsel for the petitioner that about 5 months ago, the informant's family made a proposal to the petitioner to marry the sister of the informant. However, when the family members of the present petitioner refused the said proposal, the informant's family members insisted on solemnization of marriage of the petitioner with the sister of the first informant. It is also submitted by learned counsel for the petitioner that thereafter on 10/12/2023, the sister of the first informant along with her family members came to the paternal house of the first informant, or paternal house of the present petitioner, and threatened them that unless the marriage of the petitioner is solemnized with the sister of the first informant, they would falsely implicate the present petitioner in some case and will send him to jail. On this, the present petitioner had filed a complaint before the additional district magistrate Borpeta to initiate a proceeding under section 107 of the CRPC. Learned counsel for the petitioner has submitted that the petitioner is a government servant
Yes.
working as
Assistant teacher,
assistant teacher at where?
yours, Maladhara, yours.
Assistant teacher, and he is
Maladhara Gov Junior Basic School.
ready to cooperate in the investigation. On the other hand, learned additional public prosecutor has produced the case diary of Polgosia Police Station case number 186/2023, and has submitted that from perusal of the materials in the case diary, including the statement of the victim girl recorded under section 164 CRPC, it appears that the petitioner and the victim girl were in a relationship since last 1 year, and the victim used to go to the petitioner's house whenever he used to call him. Stop.
And that very day also she went, he took her to his house.
And on
10, 12.
10/12/2023 also, the victim went to the
uh,
house of the petitioner
On being
on
called
being called by
yes.
the
petitioner.
present petitioner. Stop.
And she stayed there for many days.
And she herself stayed there for a few days. Stop. I have considered the submissions made by learned counsel for both the parties and perused the materials available on record, including the case diary of Kolgosia PS case number 186/2023. Since it appears from record that the petitioner and victim were in relationship since last 1 year, and on the date of alleged offense, the victim herself went to the petitioner on being called by the petitioner, this court is of considered opinion that if the petitioner cooperates in the investigation, his custodial detention may not be necessary for fair completion of the investigation. Stop. Hence, the petitioner Hafizur Rahman is hereby directed to appear before the investigating officer of Kolgasia PS case number 186/23 within a period of 10 days from the date of this order and cooperate in investigation. Stop. If he does so within the stipulated period of time, comma, in the event of his arrest in connection with Kolgasia PS case number 186/2023, the petitioner named above shall be allowed to go on bail of rupees 30,000 with one surety of like amount, subject to the satisfaction of the arresting authority with following conditions. Condition number 1 and 2. With above observation, this anticipatory bail application is hereby disposed of.
Item number 8.
1050 Tamil Nadu.
May I please, your lordship? This is an application under section 438 of CRPC, your lordship. The FIR, your lordship, the vernacular is at page 18, your lordship. The petitioner is an associate professor of Amguri College, your lordship.
The FIR is at
Page 18, vernacular, your lordship. And translated is, your lordship, is at page 14.
okay.
শিৱসাগৰ আমগুৰি মোৰ বুৰঞ্জীময় প্ৰৱক্তাৰ ওচৰত আমগুৰি চাৰিসীমাৰ ভিতৰত থকা মূল্যৱান খাচী গছ মহাবিদ্যালয়খনৰ বন্ধ দিন খাচী গছৰ বজাৰ মূল্য পূৰ্ত কৰা দিওঁ ইয়াৰ পৰা বিভিন্ন চৰকাৰী চোৰাং বিক্ৰী সম্পত্তি পাহাৰ হৈছে মহোদয় উত্তৰংগৰ পুঁজি অপব্যৱহাৰৰ লগত আইনী ব্যৱস্থা ল'বলৈ এজাহাৰ দিল। Now, your lordship, the allegation is not by the college, your lordship will kindly note. That is by one person from NGO, your lordship. Now, your lordship, I am neither principal nor, your lordship, any other authorized person of the college, your lordship. I am an associate professor, your lordship. Now, since 2015,
You
I
are
am,
named in the FIR.
yes, your lordship. This is
Where is your name?
Your lordship.
Roshan Borua.
Triluson Bora, your lordship. Now, had this been done by me, your lordship, the college authority would have filed an FIR, your lordship. And he is saying that since 2015, your lordship, 9 years I am doing this, your lordship, in the college. College will remain silent. Is it absolutely, your lordship, absurd allegation, your lordship? Just to, your lordship, to blackmail me, this FIR has been lost, your lordship. And if someone will be responsible, it is the college principal will be responsible. And he will lodge FIR if I have done anything since 2015.
Where is the mention that since 2015?
Here, dear lordship,
Yes. yes.
খাচী গছ প্ৰায় 2015 চনৰ It is, I could have understand that had this FIR been lodged by the college authority, then the property belongs to the college. Who is this person, your lordship? I will comply, your lordship.
Lordship, in the first paragraph, below, last 5 lines, may I read, Lordship? The aforesaid professor has gathered lots of property by selling the valuable society of the college. The aforesaid facts clearly revealed in the decision taken in the meeting of the executive committee of the college, Lordship.
That has not been, your lordship, part of the FIR, your
But
lordship.
it is in the year 2015.
15.
FIR is lodged in 24.
9 years, your lordship. Let CDB call for, your lordship, and we need
Let the
time.
case diary be called for. Heard Mr. S. Brodhakur, learned counsel for the petitioner. Also heard Mr. K. A. Das, learned additional public prosecutor. This application under section 438 of the Code of Criminal Procedure, 1973, has been filed by the petitioner Trilochan Bora, who is apprehending his arrest in connection with Amguri Police Station case number 1/2024 under section 379/409 of the Indian Penal Code. The gist of accusation in this case is that on 4/1/2024, one Diganto Soikya, President Amguri Nirman Committee, has lodged an FIR before the officer in charge of Amguri Police Station, inter alia, alleging that the petitioner, who is a professor at Amguri College of Sibsagar, is alleged to have been cutting down the within inverted comma Hasi, SASI, Hasi trees, which are grown in the college campus, and he has accumulated lot of property by selling the valuable Hasi trees of the college. Though and just don't write. The executive committee has taken a resolution, but they have not filed an FIR. What is your submission?
Lordship, they have not filed any FIR, Your Lordship. I am not aware about any resolution of the managing committee, Your Lordship. And had there been any resolution, Your Lordship, would have filed an FIR, Your Lordship. Because, Your Lordship, and in fact, there is no such, Your Lordship, actions, Your Lordship. I could not have, Your Lordship. Your Lordship may call for all those materials in the case that it will be available, Your Lordship. But the allegation itself is a very general and vague in nature, Your Lordship. Had I misappropriate property of the college, it is the college authority, Your Lordship, who would have, Your Lordship, come up and file an FIR, Your Lordship.
It is also alleged in the FIR that in this regard, the executive committee of the college has also taken a decision. Stop. Learned counsel for the petitioner has submitted that the allegations leveled in the FIR against the present petitioner are not true, and he is not aware of any resolution adopted by executive committee of the college in this regard. Learned counsel for the petitioner has also submitted that the petitioner is neither the principal or any office bearer of the college management committee, and no FIR in this regard has been lodged by the college authority. It is also submitted by learned counsel for the petitioner that the petitioner is ready to cooperate in the investigation. On the other hand, learned additional public prosecutor has submitted that the perusal of the case diary would be required for consideration of the instant bail application. Stop. Hence call for the case diary fixing
Lordship, on
February,
2nd February.
fixing 2nd February for the case diary. However, in the meanwhile, considering the fact that the allegations leveled in the FIR is for the period since 2015, that is since last 9 years, the petitioner, namely Trilushan Bora, is in the meanwhile is hereby directed to appear before the investigating officer of Amguri PS case number 1/2024 within a period of 10 days from the date of this order and cooperate in the investigation. Stop. If he does so within the stipulated period of time, in the event of his arrest in connection with Amguri PS case number 1/2024, the above named petitioner shall be allowed to go on interim bail of rupees 30,000 with one surety of like amount, subject to the satisfaction of the arresting authority with following conditions. Condition number 1 and 3. Let this case be listed again on 2nd of February for case diary.
Deeply obliged.
Item 6.
Let me do lordship. 439 application lordship, in this issue lordship, petitioner is inside the jail for about 1192 days lordship, 1192 days lordship. For about 3 years, 3 months, 5 days lordship.
POXO is there.
No, it's a NDPS case lordship and
Item number,
item number 6
bail application 189.
lordship, 190.
I could elect this.
In this case, lordship, there was a specific direction from this honorable court to conclude the entire trial within 6 months, lordship. One
Earlier you approached this court
earlier, no, the other
in a different case.
lordship, other co-accused, he approached this honorable court. In that case, lordship, this honorable court passed the direction to conclude that entire trial within 6 months. But that cannot be concluded. Still, the case is in the evidence stage, lordship. It is from Kamrup Metro, lordship. Can it be next week, lordship?
Heard Miss Eskin Herkes, Learned Counsel for the petitioner. Heard
M. Decca.
Miss M. Dekan, Learned Counsel representing the NCB. Perusal of the scanned copy of NDPS case number 16/2021 would be necessary for consideration of the instant bail application. Hence, call for the scanned copy of the NDPS case number 16/2021 from the Court of London. Which court?
From additional sessions number 2, Metro, lordship.
From the Court of London Additional Sessions Judge number 2, Kamrup Metro. Registry to issue requisition for, registry to take steps for requisitioning the aforementioned scan copies. Let this matter be listed.
There
Where
is on 24, lordship.
will it arrive?
It's from Metro.
Let this matter be listed on 24th of January 2000.
Deeply obliged.
Item 5.
I was fine, Sarsit Mala, dialogue going on. And I call. when I
Yes, Chair.
call.
Heard Miss N. M. Deka, Learned Counsel for the petitioner. Also heard Mr. K. K. Das, London Additional Public Prosecutor. Perusal of the scanned copy of the scanned copy of the special POXO case number 120/2023, along with the scanned copy of the case record of case diary of Shampur PS case number 31/2023 would be necessary. Hence, call for the same. Also, you have to make the victim party in this case. Who is the victim? It appears that who is the victim or the parents of the victim? Anybody? Who is Abida Khatun?
Abida Khatun
Is the victim.
Victim.
Where is the address of the victim girl? It appears from record that the victim
In the Sarsit Mala, case number 15.
has not been made a party in this case,
I will
as
allow my-
this case involves an offense under section 6 under POCSO Act. Hence, the victim has a right to be heard at the time of consideration of the instant bail application. Hence, the registry is directed to implead the victim whose name is available at column number 8 of the charge sheet at page 15 of the bail application. After impleading the registry would implead them as a party, you have to take steps. After impleading the victim as a party, the petitioner shall take steps for issuance of notice to the victim as per the mode prescribed in the case of Deepak Nayak versus State of Assam by a division bench of this court. Let the petitioner shall take steps within 3 days from the date of this order for issuance of notice on the victim as per the aforesaid mode. Let this case be listed again on 2nd of February
Yes.
for case records as well as service report.
Item 7.
May I please, Your Worship. FIR is at page number 13, is a 439 application. Page number 13, Your Worship.
Whether case diary would be required.
Worship may have this matter, Your Worship, because it's a civil dispute and at best it's a boundary dispute, Your Worship. He's behind the bar since 2612. If Worship not satisfied, then case may be case record may be called case diary. Worship, now Your Worship, annexure 2, page number 17 is
Now,
the.
why it was rejected by the lower court? Where is the rejection order?
Worship, I have not annexed the rejection order, but it has been rejected because early stage, Your Worship.
After perusal of the case diary.
Yes, Worship.
So
Because
case,
only on 8, Your Worship, there was vacation, Your Worship. After 8, it was listed, Your Worship. Now, Your Worship, may kindly see page number 17, Your Worship. This is the forwarding report. He has been arrested on 26/12/2023, Your Worship. Now, this is the dispute between the informant and the father of the petitioner, Your Worship, regarding a plot of land, Your Worship. Worship, may kindly see page number 18. Page number 18, Your Worship.
yes,
Send lead number 3654. Dated 29/5/1992, Your Worship. Purchaser name is, Your Worship, Abdul Hannan. Abdul Hannan is the father of the petitioner, Your Worship. And seller is Srimati Rebati Das. She is the seller, Your Worship. Now, schedule of the land, Your Worship, may kindly see. Miadi Patta number 220.
now what is the allegation against it?
Allegation is that, Your Worship, from the same seller, Your Worship, the informant and the petitioner purchased plot of land. Petitioner purchased in Dag number 81 and the informant purchased land from Dag number 79, Your Worship. Now, Your Worship, what happens? Somehow petitioner's name has been mutated. Jamawandi, his name has been recorded, and Lordship value has been assessed. Notice has been served under section
Case diary
22 of
would be
Municipal
required.
Act. Your
In
Lordship.
the.
We are fixing a short date.
Lordship,
We are fixing a short date.
already they are granted bail, Your Lordship. Lordship, kindly pay the last order.
30.
Co-accused.
Oh, yeah, no, anticipatory bail, Your Lordship, absolutely. Page number 48, Your Lordship. Father, Your Lordship, sister, all of them. Being he is a dominant position, Your Lordship.
But if you look into the 17 page number, Lordship, the forwarding report, there is the thing, my lord.
I have a division bench.
Yes. Is it 26?
We- Or if you want to continue, we will continue after rising of the division bench. If you want to insist on hearing,
No, Lordship, in that case, Your Lordship, a short date maybe.
38, Lordship, 30.
okay,
No,
heard,
Lordship.
heard Mr.
RH would be.
R. H. Chaudhary, learned counsel for the petitioner. Also heard Mr. K.K. Das, learned additional public prosecutor. Perusal of the case diary would be required. Hence call for the case diary fixing
25th question.
25th, one for case diary. Yes, Mr.
Obliged, Lordship.
And item number one, it was diary was called for, but case diary is not here.
Not here.
So
Intimation.
main list item number one.
Okay. We issue reminder. Heard Mr. A.I. Uddin, learned counsel for the petitioner, also heard Miss S. Jahan, learned additional public prosecutor,
Okay.
who prays for another date for producing the case diary.
Jahan,
The prayer is allowed.
The intimation has gone on 8th. So any date after 4-5 days?
Prayer is allowed. Let this case be listed on. When do you want?
24th,
25th?
24th.
25th,
No.
25th January for case diary.
Few matters are left, Lordship will sit after rising.
After rising, I will again. If we rise early. With certain conditions. You have to see the order after some time, to make some corrections.
Yes, yes. Marvelous.
Item 19.
May I please, Your Lordship? 438 application number. The FR is page 11. May I read my name?
The mother was assaulted by the accused.
The case diary is there.
No, case day is not, it has come up for
It is
motion.
motion, madam.
Only the problem is she has sustained injuries and it is said to be serious.
Actually,
Let the medical report come and
Lordship, one submission before Lordship, madam. That actually what was happened, my lord. This is the case of Lordship 335 actually. Both the victim and the petitioner is the fisherman. And last few occasions, my lord, the victim woman always caught the fish from the net of the petitioner in early morning.
Okay.
Innocently speaking, my lord, there is some assaulting is there, but
For
not
reasons for assault is there, but assault is
assaulting
also,
is there, but this is not as alleged in the affair.
no,
that will come to know from the case diary.
we are fixing a short date
In fact, my
because this is, FIR is in the month of November.
Lordship, kindly see, the affair is lost on November to
28th of November.
20th of November. The alleged incident was took place in 1711, and our home and the PS is hardly 150 meters.
But she was under treatment.
Mother has filed against her son.
No,
Son-
son has filed
son has
against
filed. Against me
for her mother,
for her.
for
mother.
his mother. And they were busy in treatment because she was referred to other hospitals.
No, what is the relationship of victim and the petitioner?
Neighbor,
Neighbors, they know each
neighbor.
other.
And she's
Then
freely
let
moving-
us call for fix a short date
Not sure.
because grievous injury is alleged.
Along with the injury report, I'll bring that.
Heard Miss,
fever.
this is item number,
9.
heard Miss P. Bora, learned counsel for the petitioner, also heard Miss S. Jahan, learned additional public prosecutor. Considering the nature of allegations leveled in the affair, perusal of the case diary would be necessary for consideration of the instant bail application. Hence, call for the case diary. Fixing
Fixing, Lordship 25th or, yes, 25th of January,
Fixing 25th January for,
Thursday, coming Thursday, 24th. Wednesday. Oh, this is from Johar. Okay, we'll give a try then.
fixing 24 January for case date.
Problem.
This one application, under section 439, my lord. Petitioner was arrested, my lord, on 4/12/2023, as on today, my lord, about 46 days in the custody.
Like,
My lord, in this case, my lord, I had received a summon after submission of the charge sheet. Now, during the course of investigation, I did not receive any summons
copy
or
has-
notice.
NCR is here.
But this is a case involving commercial quantity of.
Right.
110 point something kgs of.
So what is your submission?
Yes, Madam, the trial court has rejected considering the Madam, the section 37 1B. Lordship may kindly have a look to the Madam order. Page 48.
Page 40.
8. So it's a long order, Madam. Let me come, page 51 onwards, Madam. The accused, second paragraph, page 51. The accusation against the accused persons in this case is of commission of an offence under section 20B2C of NDPS Act. As per allegation in the FIR, 110.045 kg of suspected ganja in total 12 polythene packet was seized from the house of the accused, Moina Kosari and Tulsi, who revealed during interrogation that his son Haren Kosari and the accused person Gogoi Deuri, that is me, and Pranjal Deuri had brought the said suspected ganja for business purpose. After completion of investigation, the IO submitted charge sheet under section so-and-so against the accused person, Pranjal Deuri, Haren Kosari, Moina Kosari, Tulsi, Gogoi Deuri, so-and-so. It is found that on 15/12/22, 31/12/22, 5/1/23, 17/2/23, and 28/4/23, house search was conducted in the house of the accused Gogoi Deuri alias Pallav Rajkumar Deuri in connection with Narayan PS case number 78/2022 corresponding to this case, and the search list were filed along with the charge sheet. As the case involves commercial quantity of ganja and the learned additional PP has opposed the bail prayer of the for the accused Gogoi Deuri, the limitation on granting of bail specified in section 37(1)(b) of the NDPS Act are attracted in this case. Further, as charge sheet has been submitted under the above section, there appears reasonable ground for believing the commission of the offence in question on the part of the accused person. Considering the merit of the case and also taking note of the fact that the accused Pallav did not cooperate with the IO during the investigation of the case, I am not inclined to grant bail to the accused Gogoi Devi. Now, my lord, while observing that the limitation of granting bail under section 37(1)(b) of NDPS Act are attractive, it is, my lord, the satisfaction of the court that in case of granting bail, then court has to be satisfied the requirement by mentioned by the section itself. 37(1)(b). No person accused of an offence punishable or offence under section 19 or section 24 or section 27A, and also for offence involving commercial quantity shall be released on bail on or on his own bond unless the public prosecutor has given an opportunity to oppose the application for such release. And where the public prosecutor opposes the application, the court is satisfied that there are reasonable ground for believing that he is not guilty of such offence and that he is not likely to commit any offence while on bail. So the court satisfaction, first of all, is that the public prosecutor has to be heard. And if the public prosecutor submits objection, then the court has to come to a satisfaction that he is not guilty of the offence. These two satisfaction, the first has been complied with, public prosecutor has been heard, but the second finding is not there, that he has committed the offence. And even remotely, the consideration that has been taken here is that the statement of the co-accused, Moina Deuri, from whose house the contraband was recovered, he stated to the police that his son and this particular petitioner has brought these goods to his house. Moina Kosari. Now, whether that, my lord, statement of the co-accused or even, my lord, that the confession of the co-accused can be, my lord, taken into consideration for the purpose of granting bail. Now, the recent judgment of the, my lord, apex court, my lord, while the High Court has granted bail, saying that these two conditions has been satisfied and the persons were granted bail, that was appealed against by the, my lord, authority, and then the apex court, my lord, in para 9 and 10, lordship will kindly find, my lord.
Which case? Para 910 of,
Oh, my lord, I'm so sorry, I'm so sorry. my lord. It's AR Online 2022 Supreme Court 130. My lord, let us, my lord, go by the facts, my lord, first of this particular judgment of the apex court. my lord. Paragraph 2 onwards. The
Yes.
facts leading to Haji Lordship,
yes,
the facts leading to registering of the aforesaid cases against the second respondent are that on 22nd March 2019, the petitioner NCB had received information that two persons, that is Naushir Muhammad A1 and Naushad Manakkam Valley A2, were going to carry drugs and travel to Doha by Oman Airways from Bangalore International Airport. Immediately on receiving such information, a team of NCB officers arrived at the airport, and on searching the luggage of A1 and A2, seized 4.527 kg of hashish, 965 grams of so-and-so, my lord, and 30 grams of cocaine. Both the respondents in SLP criminal alias diary number 22702/2020, that is Pallu Labid Ahmed, Aramutta and Muhammad Majid Salem, were arraigned as accused number 3-4 in NCB case number so-and-so and arrested for the offense stated above. Similarly, Muhammad Afzal A6, respondent in SLP criminal number so-and-so, was arrested on an allegation that his call details record reveals that he was in constant conversation with A2 and one Abu Thairi alias Abdu A5. Additionally, reliance was placed by the department on the statement of A5 recorded under section 67 of NDPS Act, which purportedly reveals that both of them had arraigned and the drugs that were.
just a minute, Mr. Secretary. Do you have case diary today?
Case diary is it? In the LCR.
Now, my lord, come paragraph 5. This, my lord, may skip, my lord, the paragraph 5. The specific allegation level against Muhammad Abdul, respondent number in SLP number so-and-so, who was granted bail by order dated so-and-so in the second case registered by NCB, is that apart from his own inculpatory statement and the confessional statement of the co-accused Abu Tahir alias Abdul, recorded under section 67 of the NDPS Act, large quantity of drugs were seized at his tenanted premises and from the handbag of the co-accused Khushbu Sharma, also found to be in his possession at the airport, which concealed drugs. Then number 6, as for Munni Kabil A5, respondent in criminal petition number so-and-so 9th, who was granted bail by order dated so-and-so in the second case registered by NCB, the basis of arresting him was the statement made against him by the co-accused A1 under section 67 of the NDPS Act, disclosing therein that A5 had sent drugs to Doha on several previous occasions on instruction received from his brother, and that he was financing the drug business. Mr. S.B. Raju K. Nataraj, learned additional Solicitor General, both appearing for the petitioner NCB in the connected petition, have challenged the impugned orders primarily on the ground that the High Court has erred in returning a finding that the rigor of section 37 of the NDPS Act are not attracted to the facts of the present case, that none of the preconditions stipulated in section 37 of the NDPS Act that starts with a non-obstante clause had been met in the instant case for granting any relief to the respondent, and that a concession has been granted to the respondent on an erroneous presumption that there is a reasonable ground for believing that they are not guilty for such an offense. It has been vehemently argued by the learned Additional Solicitor General that in the instant case,
there existed justifiable reasons to reject the bail application of the respondent, and there was hardly any ground to believe that they were not guilty of the offences alleged against them, or that they are not likely to commit any such offence while on bail. By order dated 5 January 2020, learned counsel for the petitioner NCB were directed to prepare a comprehensive tabulated statement with respect to the role attributed to each of the respondents, the evidence gathered against them at the time of their arrest, their antecedents, the dates on which they were arrested, and the period of custody undergone by them for ready reference. Then, my lord, 9, my lord. Having gone through the record along with the tabulated statement of the respondent submitted on behalf of the petitioner NCB, and on careful perusing the impugned orders passed in each case, it emerges that except for the voluntary statement of A1 and A2 in the first case, and that of the respondent themselves recorded under section 67 of the NDPS Act, it appears prima facie that no substantial material was available with the prosecution at the time of arrest to connect the respondent with the allegation level against them of indulging in drug trafficking. It has not been denied by the prosecution that except for the respondent in assembly number so-and-so, none of the other respondents were found to be in possession of commercial quantities of psychotropic substance as contemplated under the NDPS Act. It has been held in clear terms in Tufan Singh versus State of Tamil Nadu that a confessional statement recorded under 67 of the NDPS Act will remain inadmissible in trial of an offence under section NDPS Act. In the teeth of the aforesaid decision, the arrest made by the petitioner NCB on the basis of the confessional voluntary statement of the respondent or the co-accused under section 67 of the NDPS Act cannot form the basis for overturning the impugned orders releasing them on bail. The CDR details of some of the accused or the allegations of tampering of evidence on the part of one of the respondent is an aspect that will be examined at the stage of trial. Accordingly, they were, the order was not interfered. However, with the respondent A2, accused number A2, paragraph 11. However, the evidence brought before us against Muhammad Afzal, respondent in assembly was a subject matter of the second case, NCB case number so-and-so, who was granted bail by order dated 8 January 2020, will have to be treated on an entirely different footing. There is specific allegation level against the said respondent regarding recovery of substantial commercial quantity of drugs from a rented accommodation occupied by him, pursuant to which he was arrested on 16 June 2019. This aspect has been completely overlooked while passing the order dated so-and-so. So therefore, that order was set aside, but the other orders which are solely based on the statement of the co-accused or statement under section 67 of the NDPS Act, it cannot be taken into consideration at all. Now here your lordship will find from the order itself. First is that the person whose possession the goods were recovered, Moina Kosari, on the basis of his
Now,
statement.
who is before this court today?
Gogoi Deuri, Pallab Gogoi.
Pallab Gogoi.
Gogoi Devi alias Pallab Gogoi alias Rajkumar Devi. Other co-accused have been granted bail by this honorable court, of course, on a ground that the trial has not been proceeded. So sufficient time they were inside the custody, they were granted bail. Those orders I have also annexed here.
That benefit.
Now here your lordship will, I am not claiming at this stage of that benefit. Here you have the narration of the facts. What I have stated in the petition is that
There is no other material except
that
statement
statement,
of.
there's nothing, no
But-
recovery, nothing.
But your house was searched.
But nothing was recovered, and that is a police statement, madam.
Whether something was recovered
Nothing,
from.
madam, nothing.
No, in
Entire
fact,
goods were recovered from the Moina Kosari. That is, there is no dispute. Nothing was.
no, they do the business, all of them do the business together and it is being collected at Moina Kosari's place. Because apart from the statement of the co-accused, 161 statements are found of the independent witnesses. They have said that since long they have been doing business and Deuri is involved. Those independent witnesses' statements are there. They know, they are neighbors. I'll read out one or two. Lordship will see. It's a very small statement. Yeah, one of
No,
them is some
No,
Babul.
let me put queries.
Yes, yes.
The allegation in this case is that
Mm.
on search of
Yes.
from whom
Moina Kosari.
Moina
from
Kosari.
Moina Kosari.
Yes.
Moina Kosari's possession,
Hmm.
some
110.1.
110 points, so
Hmm.
much of what was found?
Ganja.
Ganja
Cannabis.
was found.
Yes.
110.0.5 kg of
Ah.
ganja was found. And he said that I brought it and that the present petitioner had
Hmm.
procured the same and given
Hmm.
it to him.
Hmm.
Apart from his statement, what else is there to connect
Witnesses, the neighbor statement is there.
regarding this
Gogoi Deori.
This recovery.
this recovery?
This recovery.
Okay, well,
This recovery, people have said, we have gone, we have seen the items were recovered from Moina Kochari.
Hmm.
And they further say that Moina Kochari's son, some Horen Kochari, since long has been in this business. Along with them, Gogoi Deori is there. This is their statement. This is what they say. Horen ঘটনার ময়নাৰ কাছাৰীৰ ল'ৰা হৰেণ কছাৰীয়ে দীৰ্ঘদিন ধৰি অবৈধ ভাং ব্যৱসায় চলাই আহিছে। সেই ব্যৱসায়ত গগৈ দেউৰী উৰুফে বিপ্লৱ নহয় পল্লৱ আৰু প্ৰাঞ্জল দেউৰী নামৰ ল'ৰা দুজনো জড়িত আছে বুলি জানো। These are all of course hearsay. They know.
Yes, statement under section
And one of the accused has also said in his 161 that he is also involved in the same business.
no, if independent witnesses depose that you are indulged in such activities since long, can we say that there is no implicating materials?
Malad, these are, Malad, statement that has been recorded under section 67 of the Act.
161.
161 of
Malad,
CRPC.
this is same, Malad,
Same,
this
same.
is, Malad, NDPS, so, Malad, it has to
Mhm.
be taken as a 67, Malad, power to call for information, etc.
No, but this is not from co-accused.
Mm.
This is from the independent witness.
Independent.
Malad, any officer referred to in section 42 who is authorized in this behalf by the central government or a state government may, during the course of any inquiry in connection with the contravention of any provision of this act, call for information from any person for the purpose of satisfying himself whether there has been any contravention of the provision of this act or any rule or order made thereunder. Require any person to produce or deliver any document or things useful or relevant to the inquiry. Examine any person acquainted with the facts and circumstances of the case.
This is in addition to 161.
This is a self-contained code, Malad. No one has said, yes, I have seen him bringing the, this particular consignment, to the house of the Moina Kosari.
And not only one, there are
No,
others
what is
also.
inadmissible is confessional statement only.
Mm.
No, even, Malad, the, subject to, Malad, with all respect, Malad,
Statement of other normal witnesses is also inadmissible.
Malad, that has been mentioned, Malad, in the judgment, statement, Malad, followed, under, recorded under section 67.
No, Tufan Singh says that confessional
No,
statement
confessional statement, but.
or
Yes.
the confessional statement of co-accused
Co-accused,
who implicate you.
Yes.
But whether the statement of witnesses
Mm.
who are not otherwise
Accused.
accused in
Mhm.
that case.
No, I'll just read once again, Malad, this paragraph.
Because statement of witnesses
Yes, Malad,
will be the basis.
yes. Malad, what it says, Malad, paragraph 10. It has been held in clear terms in Tufan Singh versus State of Tamil Nadu that a confessional statement recorded under section 67 of the NDPS Act will remain inadmissible in the
Yes.
trial of an offense
So
under the
what is
NDPS Act.
inadmissible is a confessional statement.
Yes, now the second line, in the teeth of the aforesaid decision, the arrest made by the petitioner NCB on the basis of the confession oblique voluntary statement of the respondents or the co-accused under section 67 of the NDPS Act cannot form an basis for overturning the impugned order releasing them on bail.
So the what is exempted is the statement of co-accused or your own confessional statement,
confession.
but not the statement of
Other witnesses.
other independent witnesses. Now, my query is, if the other independent witnesses have implicated you, then you will not get protection of,
My lord, the
Whether you-
implication is to what extent? That I know he is in the business.
That is of
general
course.
statement.
It's a. my
General.
lord, whether, my lord, any statement is there, yes, I have seen or I know that this consentment has been brought by my lord, the present petitioner. It's a general statement has been given, my lord.
Of
Strict-
course, that is
strict-
correct.
Strict
They-
construction
They
is
know,
required.
they have heard.
And the second aspect of the matter, your lordship will kindly see, madam, during the course of the investigation, I have never been interrogated. Charge sheet has been submitted showing me absconder. I have received a summon. Then I appeared before the court. Then my counsel, my lord, on going through the, my lord, charge sheet, it found that I have been, my lord, declared absconder. So I have preferred a revision petition before this, initially, my lord, bail application. This court, my lord, considering that the summon only has been, my lord, issued, said there is no apprehension of his arrest. So that way, that bail application was disposed of. I have instructed my advocate to take steps in the case. He failed. Thereafter, non-bailable warrant had been issued. I came this honorable court. And this honorable court, my lord, suspended the NBW and directed me to appear. Accordingly, I have appeared. Now, court has taken two, my lord, circumstances. Number one, that the statement of the Moina Kosari. Number one. And second is that on so and so, that they have gone for search in my house.
Whether in search,
Anything
anything has
recovered.
been found.
No, search was only made in Moina Kochari's place and it was recovered. He was not there.
And
Gogoi
thereafter on
Deori.
15/12, 31/12, 5/1, 17/2, 28/4, search were made
Search were made to arrest him.
or to arrest him, not
Yes.
to
No.
recover.
Search were made to arrest him because he was declared absconder and he surrendered in the month of December.
No, now my query is, section 37 would be applicable if there is independent materials.
Hmm.
If the court comes to a
Hmm.
finding that there are reasonable grounds to believe that you are guilty.
Yes.
That has to be there.
Ah,
Simply
but now-
objection will not do.
Yet,
But
Yes.
then their lordship will see the next line after the learned court writes about the objection. Lordship will see page number 52. Further, here lordship will skip the first part that my learned friend had read. Further, as charge sheet has been submitted under the above section, there appears reasonable grounds for believing the commission of the offense in question on the part of the accused persons,
yes,
considering the merit of the case
no.
and also taking
Therefore, I am
note.
putting query,
Not.
merely because charge sheet has been filed.
No, that cannot
Now,
be.
on what basis charge sheet has been filed?
But next, learned court writes considering the merit of the case.
No,
He
but
does not elaborate.
He has not discussed.
He does not discuss, but considering the merit of the case and also taking note that he
Now
was
you
an
have to only
abscond.
show me what materials are there.
Materials, yes, materials are only in respect of these statements of the
Or
independent.
any other
They know.
document linking
No,
linking
because
the present petitioner with
conscious
this
possession,
recovery.
conscious possession,
That he
those.
had purchased it, or any witnesses seeing that this was transferred, this was given to the Moina Kochari by the present witness. Any evidence to that? effect?
Only a statement of the co-accused, not only Moina Kochari, other co-accused have also said that we bring it together. Otherwise, others have not stated. Others simply they have heard, they know.
And what Moina Kosari's statement has not been recorded.
Recorded. Moina
No, no.
Kochari.
What Moina Kosari has stated?
Moina Kochari stated that these people are involved. And other accused persons also. I'll just read out Moina Kochari statement. This is the one. More naam so and so, and let's give this. Moi ejon khetiok joakali so and so tarikhe mur lora Horen Kosarie teo logor Gogoi urufe Pollab Deuri hoite ei 21টা ডাঙৰ টোপোলা দিনৰ ভাগত মই পথাৰত থকা সময়ত মোৰ ঘৰত আনি ভিতৰত ৰাখে। মই পথাৰৰ পৰা আহি ডাঙৰ টোপোলাসমূহ দেখা পাওঁ। ভাঙৰ টোপোলা, not ডাঙৰ। ভাঙৰ টোপোলাসমূহ দেখা পাওঁ। সেই ভাঙৰ ব্যৱসায় আগৰে পৰা তেওঁলোকে কৰি আহে আৰু মই সম্পূৰ্ণ জ্ঞাত।
You are reading Moina Kochari.
Moina Kochari
He is
state.
himself an accused.
He is himself an accused.
Okay.
Co-accused statement.
That is
Then again, that rigors will come.
if he is himself an accused, then 67,
Hmm.
then Tufan Singh's judgment will come that
Yes, that will
on
not be.
basis of his statement alone,
Hmm.
the accused cannot be apprehended.
Mm.
Some other material must be
Mm.
there.
His statement, along with other co-accused, along with these hearsay evidence of the other witnesses. That's all. Nothing has been recovered from him. It is recovered from Moina Kochari, but these people are involved. This is the case.
What
None
is-
of the independent witnesses have said about,
Any other material, any other evidence?
I don't find any absconding. He was absconding. That is additional. Number of searches were made. He surrendered after he got the order from the High Court.
Sorry.
Surrendered bill, he said.
I appeared as per direction of this court.
Oh, but then, acha, court right surrender. It was sir, the first page of your order.
Heard,
Acha.
Mr. P. J. Soikya, learned senior counsel assisted by Mr. P. Bordoli, learned counsel for the petitioner. Also heard Ms. S. Jahan, learned additional public prosecutor. This application under section 439 of the Code of Criminal Procedure, 1973, has been filed by the petitioner, Shri Gogoi Deori, alias Pallab Deori, alias Rajkumar Deori. What has happened to other accused persons?
They are released on bail by this court.
All other accused,
All are accused.
on some other ground. You have bail orders.
Yes, I have annexed my book. Page 50.
Last word. And so, who has been detained behind the bars since 4/12/2023 in connection with special NDPS case number 18/2023 under section 20B2C of the NDPS Act and pending before the Court of Learned Additional Sessions Judge within bracket FTC Lakhimpur, North Lakhimpur. The gist of accusation in this case is that where is the FIR?
That's page 18.
That on 13/12/2022, one Rikumuni Medhi, SI of police, lodged an FIR before the officer in charge of Narayanpur Police Station, inter alia, alleging that on receipt of an information through reliable sources that some persons are selling suspected ganja. No, that one Moina Kochari is selling suspected ganja in his residence for business purpose, and a search operation was conducted in the residence of said Moina Kochari, and 110.045 kg of suspected ganja was recovered from the residence of said Moina Kochari. On receipt of the said FIR, North Lakhimpur PS case number 78/22 under section 20B2C of the NDPS Act was registered and investigation was initiated. Stop. After completion of the investigation, charge sheet was laid against how many accused persons?
4.
Against 4 numbers of accused persons, including the present petitioner,
Showing absconded.
showing him as an absconder in the charge sheet, in the column number 2 of the charge sheet, comma, under section 20B2C of the NDPS Act. It is submitted by learned counsel for the petitioner that though the petitioner was shown as an absconder in the charge sheet, he never received any information. He was never interrogated. He was never searched by the police during the course of investigation. And accordingly, he appeared, he had preferred and so not according. And after receiving summons from the trial court, he preferred a criminal petition which was registered as 1258/2023, wherein he was directed to, before that line, summons were issued, and thereafter non-bailable warrant of arrest were issued against the present petitioner. Officer, accordingly, criminal petition was preferred. Criminal petition was preferred by the present petitioner, wherein by order dated 30/11/2023, the petitioner was directed to appear before the trial court, and the non-bailable warrant of arrest issued against him was kept in abeyance till 4/12/2023. It is further submitted by learned counsel for the petitioner that in pursuant to the directions of this court, the petitioner appeared before the learned trial court, that is the Court of Learned Additional Sessions Judge, FTC, Lakhimpur, on 4/12/2023, and had preferred a bail application. However, the said application was rejected by the trial court on the ground that the embargo of section 37 of the NDPS Act, 1985, is applicable in the instant case.
That may take you lots of inconsideration for another court.
Yes.
Yes, my
In the instant case, learned senior counsel for the petitioner has also submitted that in the instant case, apart from the statement of the co-accused, which were recorded under section 161 CRPC / section 67 of the NDPS Act, 1985, no incriminating material could be collected by the investigating officer against the present petitioner, and hence learned senior counsel has also submitted that in terms of the judgment of the apex court in Tufan Singh versus State of Tamil Nadu, reported in within bracket 2021 4 SCC page 1, the confessional statement recorded under section 67 of the NDPS Act will remain inadmissible in trial, and it is inadmissible in trial. Learned counsel for the petitioner has also cited a ruling of the apex court in State versus Pallu Labid Ahmed Arimutta and others reported in AIR Online 2022 SC 130, wherein it was observed that that the confessional statement / voluntary statement of the accused / or the co-accused recorded under section 67 of the NDPS Act, 1985 cannot form the basis of overturning the orders releasing the accused persons on bail. Stop. Learned senior counsel for the petitioner has submitted that for applying the embargo of section 37 of the NDPS Act, 1985 in the instant case, some other material must be there against the present petitioner apart from the statement of the co-accused, which were recorded under section 67 of the NDPS Act / 161 of the Code of Criminal Procedure. However, in the instant case, no such material is available on record, and therefore it is submitted by learned senior counsel for the petitioner that for the purpose of consideration of the instant bail application, it can be stated that there is no reasonable ground for believing that the present petitioner has been guilty of the offense alleged against him in this case. It is further submitted by learned counsel for the petitioner, senior counsel for the petitioner, that in the meanwhile, the other co-accused persons, namely Moina Kochari, Pranjal Deori, and Haren Kochari. Where are the bail orders?
Lordship, page 54 and extra L, Lordship. It starts from page 55, Your Lordship.
Have already been granted bail by a coordinate bench of this court in bail application number 3067/2023 by order dated 18/10/2023. Stop. On the other hand, learned additional public prosecutor has produced the case diary of has submitted that has submitted that the scanned copy of the case diary of the North Lakhimpur PS case number which is the PS case.
Lordship, it is not Lakhimpur, Lordship, it is Narayanpur PS case.
Narayanpur PS case number
78/2022.
78/2000 is available.
2022, Your Lordship.
2022 is available, and on perusal of the case diary, it appears that there are implicating materials against the present petitioner in the case diary. However, the said implicating materials are the statement of the co-accused Moina Kochari and other co-accused who have stated in their statement made under section 161 CRPC that the present contraband was given to was kept in the house of the Moina Kochari by the present petitioner along with other accused persons. Learned additional public prosecutor has also referred to the statement made by other witnesses under section 161 CRPC, wherein they have stated that they know that the present petitioner is indulging in the business of illicit drugs since long. Stop. I have considered the submissions made by learned counsel for both the parties and have gone through the materials available on record, including the scanned copy of the case record of NDPS, special NDPS case number 18/2023, as well as scanned copy of the case diary of Narayanpur PS case number 78/2022. On perusal of the materials on record, it appears that apart from the statement of the co-accused persons recorded under section 161 CRPC, there is implicating the present petitioner with the seized contraband. There is no other material on record. Though there are statement of witnesses recorded under independent witnesses recorded under section 161 CRPC, wherein they have stated that the present petitioner has been indulging in the business of illicit drugs since long. However, no specific statement has been made by any independent witness linking the present petitioner with the contraband which has been recovered from the house of Moina Kochari in this case. As submitted by learned counsel, as already held by Apex Court in many of its judgments, mainly in Tufan Singh versus State of Tamil Nadu within bracket Supra, wherein it has observed that the statement of the confessional statement of the co-accused recorded under section 67 of the NDPS Act, 1985 is inadmissible in trial, and same may not be the basis for refusing the grant of bail to a petitioner, to an accused persons, to an accused. Stop. This court is of considered opinion that as presently this court, for the limited purpose of consideration of the instant bail petition, is of the considered opinion that as presently, apart from the statement of the co-accused, there is no other material against the present petitioner. Hence, and as the said statements are inadmissible in evidence, hence, for the purpose of consideration of the instant bail application, this court is of opinion that there are reasonable ground to believe that the petitioner is not guilty of the offense alleged in the affair. Further, there is regarding that he will not commit the, what is your submission? That you will not,
Lordship. Lordship.
no, there is one more condition. That second requirement, that you will not, this court must come to this that you will not commit the, if you are released on bail, you are not likely to commit any offense while on bail. How that satisfaction? You have been arrested earlier also,
No, Lordship.
no criminal
No,
antecedent.
Lordship.
As learned counts, as there is no material to show any earlier criminal antecedent of the present petitioner involving him with other pending cases. There is also no ground to believe, there is also no material to come to a finding that if he is released on bail, he may commit any other offense. And therefore, this court is of considered opinion that the embargo of section 37 of the NDPS Act is not applicable in the case of present petitioner.
That
In-
condition is there in 37. I was not aware.
It is there.
Achha. Another embargo.
Two conditions are there. One is that,
Hmm.
one,
Unless he is opposes.
and second one is
Ah.
that if he is released on bail, he will not
Oh, yes.
commit offense.
There is
So
no
that
way he is
for,
not
if
released
he is released on bail and he will
Ah.
commit offense, some material must be there.
Ah, yes.
Some criminal antecedent must be.
Antecedent will show otherwise.
For reasons mentioned herein above, the petitioner, namely so-and-so, is allowed to go on bail of rupees. What was the condition for other co-accused persons?
Lordship. It is in page 56, your Lordship. Paragraph 8, Lordship.
1 lakh.
1 lakh,
Paragraph 7 and 8, Lordship.
Bail bond of 1 lakh
Bail
with
bond
two
of-
suitable charges.
rupees 1 lakh with
Each.
2 sureties of like amount. And one of whom should be a government servant to the satisfaction of learned additional session judge FTC, Lakhimpur, North Lakhimpur. With following conditions, that the petitioner shall not leave the territorial jurisdiction of the trial court without prior written permission of the learned session judge, learned additional session judge within bracket FTC, Lakhimpur, North Lakhimpur. Number 2, the petitioner shall not directly or indirectly make any inducement, threat, or promise to the facts of the case so as to dissuade such person from disclosing such facts to any police officer. No, to any court or to any police officer. The trial court shall be at liberty to impose any additional condition for bail if it deems fit to do so at the time of releasing the present petitioner on bail. With above observations, this bail application is hereby disposed.
Obliged.
Both finish. Ask it.
Item number is 13, Lordship. Case there is also here. They are not on interim, Lordship.
Date
Can be taken up on Monday then?
Monday. Heard Mr.
B. Haldar, Lordship.
B. Haldar, learned counsel for the petitioner. Also heard Ms. S. Jahan, learned additional public prosecutor. This matter could not be taken up due to paucity of time. Let this matter be listed again on Monday.
CD may be written.
On 22nd January, the case diary may be retained till next day.
Lodge. Of like. Number 13 is